viewers. Welcome to another episode of Immigration for All, presented by Nora Global and powered by Comet. For today's session, I am your host, 𝗣𝗏𝗶𝘁𝗶𝘆. You may already know that we have rebranded our popular Monday Live series under this new banner to better reflect our mission of providing comprehensive immigration insights. As a part of this revamp, we're excited to announce this session, which will also be available in podcasts like Spotify and Apple Podcasts, allowing you to tune in to our live session at your convenience. For today's session, our topic is how to port or retain an I-140 priority date, part 2. Without any delay, let's welcome our guest speaker, Mr. Raju Mahajan, the principal attorney of Raju Law. Hello, Mr. Mahajan.
Th-
Thank you so much for joining. How are you doing?
Thank you. I'm very good. Thank you very much, David. Thank you for inviting me today. It's a great pleasure. How are you?
I'm doing fine as well. Thank you so much.
Thank you. Thank you. Yeah. So I would like to directly talk about our topic today. I would like to go for the presentation. All right. So those who joined our session in last Monday, those who has viewed it, you know that the topic is how to port or retain a priority date. Today is the part 2. So many of you, if you did not watch our previous video, please watch it before you watch this one. In that way, you will better understand it. If you did not do it, that's okay. You can watch it now, and then you can watch that one. So bottom line is, today is the second part of how to port or retain a priority date content. Next slide, please. All right. So what we have discussed in part 1 in the previous session is we talked about what is porting, what is retaining a priority date. We gave 6 examples. So those examples are kind of like self-explanatory, but if any of you have any question, you can always reach out to us. We'll explain more. And also, what were the eligibility requirements for porting or retaining a priority date? So those were the topic for our previous video. Now we're going to the next slide for today's video. Next slide, please. All right, so what we are going to discuss today, what is in part 2? We are going to tell you what is the filing requirements, what is petition considerations. There are some things you need to consider before you submit your petition. Portability provisions, there are some provisions, you must know it. Decision on transfer request, how USCIS make decision and what is the impact on that. And also derivative beneficiaries adjustment of application. By the way, as I tell in all of our videos and audios, that the purpose of this video and audio is just to give you an overview. That's just to give you information. This is not a legal advice. Please do not depend 100% on this video or any video on YouTube. Talk to an expert, talk to an immigration attorney before you make any big move, because immigration is a big journey for your life. So please take it seriously. Again, this is just for the information purpose only. This is not a legal advice. Please do not make any decision solely based on this video. My purpose of this video is just to make you understand the process. Next slide, please. All right. So what are the filing requirements? By the way, when I make this kind of PowerPoint slides and talk in video or audio, I cannot cover everything, right? Because everything is a big topic. Law is a very complex matter by itself, and immigration is an even complex matter. So I cannot tell you all the requirements. I am only giving you highlights so that these are the main things, and on the top of that, there are definitely other requirements that you need to fulfill. So generally, no new adjustment application or filing fee is required. Here, please pay attention to the word generally. It says that generally there is no new adjustment of application or filing fee. Meaning, let's say you file for a adjustment of application at status before, and then you are trying to port or retain the priority date for a new application. So for the new application, you do not need to pay additional fee. However, this is the interesting part. However, there are some special circumstances where you may need to pay additional fee. There's a $1,000 fee. Again, I'm not going that detail here. We discussed about those in the previous session. So yes, if you want to learn more, please go to the previous video and watch it, video or audio. All right. The next requirement is the adjustment application must request in writing that USCIS transfer the applicant's pending adjustment application from one basis to another. It must be a writing and to USCIS. However, however, there are some situations. So let's say you applied for adjustment of status before, you went to the interview, and in the interview, you were telling the USCIS officer, hey, I have another adjustment of application pending, and I would like to retain that priority date in this application. You can say that. In that, if you say that, what officer will do is officer will give you a paper, a white paper and a pen, and officer will ask you to write it down. So you will write it down, you will sign it, give it to the officer, and most likely officer will postpone your interview immediately because you're going to port a previous applied petition's priority date. So officer will most likely postpone the interview, will schedule another interview and examine the previous file and port the previous priority date. So that can also be possible, but in general, the adjustment of status application must be requested in a written format to USCIS before your interview or anything. Yeah, next slide, please. All right, petition considerations. There are four scenarios, four main scenarios, I must say. So I'm going to talk about those four scenarios. And of course, there are some other small matters that I'm not going to cover today. We cannot talk about everything. That is not possible. Everything depends on the background, depends on the situation. And many of my clients, sometimes they express their frustration why you cannot say yes or no, because law doesn't work that way. I try my best to make people understand that law is not binary. It's not 0 or 1. There's always gray area. There's always depends. There depends on many factors or information. So yes, we cannot say, in most cases, we cannot say yes or no. So if me or any attorney say it depends on many factors, please do not be frustrated, because this is how it should be. All right. So number one, petition considerations are approved petition to an approved petition, meaning you submitted for a, let's say, I-140 application, let's say under EB1 or NIW, that petition was approved. And then later you submitted another petition, another I-140, and that one was also approved. This is the scenario for this one. The beneficiary of an approved petition with a pending adjustment application may replace the approved petition with a different approved petition as the basis for the pending adjustment application. Meaning, if there is a previous approved petition and there's a new approved petition, then you may change the underlying basis. That's easy to do. It's between one approved petition to another approved petition. It's easy to do. No big issues here. Next slide, please. All right, the second scenario is approved petition to a pending petition. See, there's like a new scenario. Approved petition to a new pending petition. Yeah, the beneficiary of an approved petition with a pending adjustment application may replace the approved petition with here's the word may. Remember that the may word is very significant. May replace the approved petition with a pending petition as the new basis for the pending adjustment application in certain categories. The new basis must allow, there's the word must, this is not may. The new basis must allow for filing of an adjustment application prior to approval of the petition, concurrent, in bracket, in parenthesis, concurrent filing, or the transfer cannot occur and should be denied. See, I'm reading the second sentence again. The new basis must allow for filing of an adjustment application prior to approval of the petition, concurrent filing, or the transfer cannot occur and should be denied. So this is kind of a little tricky. Next slide, please. All right, the third one is pending petition to an approved petition. This is kind of the opposite of the second circumstance. An adjustment application with a concurrently filed and pending immigrant visa petition may replace the pending petition with an already approved petition as the basis for the pending adjustment application. This is also like more likely to happen than not. This is also kind of like similar situation like situation one. Most likely this will happen. Next slide, please. So this is number 4 and the last condition. pending petition to a pending petition. So meaning both of the petitions are pending. So you applied for a I-140, let's say EB1 I-140 or NIW I-140 or regular EB2 I-140. That one is pending, and there's another pending I-140, and now you're trying to transfer the priority date. An adjustment application with a concurrently filed and pending petition may request to transfer the adjustment application to another pending petition, provided that the new basis allows for the filing of the adjustment application prior to approval of the underlying petition. So if you meet the requirement, then you can do it. Kind of that's the summary of this thing. So again, these are very many times you may not understand. It's okay. The purpose of this video is just to familiar you with these terms. Next slide, please. All right, portability provisions. Adjustment of status applicants are not eligible for portability if their older approved petition visa petitions are based on EB1 or NIW. So this is a tricky part. So let's say your previous I-140 was a regular EB2 or regular EB1 or EB3, and the second one, the newer one, is EB1A or NIW, then you can transfer your priority date. No problem with that. However, if the older one is EB1A or NIW and the new one is employment based, like a regular employment based, like a regular EB2, EB3 or EB1B or C, then you cannot transfer it. So this is a tricky part. Many people ask me this question all the time, so I'm trying to explain it here. Second provisions is transferring the basis of the adjustment of status application resets the adjudication clock 180 days for purposes of portability eligibility. I'm not going that detail into 100 days calculation here. That's a whole topic for whole video that will take a long time. Just remember that transferring the basis of the adjustment of status application resets the adjudication clock, meaning 180 days, for purposes of portability eligibility. Next slide, please. Decision on transfer request. If the transfer request is granted, remember, if the transfer request is granted, the applicant is not permitted to withdraw the request or request transfer to adjustment application to a third basis at a later time, except for possible transfers between the first three employment-based categories. What it means is, once it is approved, you cannot transfer it to another basis unless it is first three employment-based categories, which is EB1, EB2, EB3 scenarios. That's the decision on transfer request. Next slide, please. All right, this is thank you, meaning last slide. But before last slide, let me talk a little bit about another thing. So many people ask me a question, hey, if I apply for transfer of my priority date from an older basis to a new basis, is my dependents, my derivative applicants, like my spouse, my children, are their application also going to be changed? The answer is yes. They are dependent. Their application depends on your application. Whatever happens to your application will exactly be happen to their application. So that's why I'm not going that detail into that topic, because it's a small, it's an easy calculation. If your priority date gets changed because of your application, then their priority date will also get changed. They will just follow you. That's the easy calculation. All right, that was our presentation today. It's a two-part presentation. We did in the first last week, and we did the second part today. If anyone has any question, feel free to ask me.
Okay, thank you so much for your presentation, Mr. Mahajan. So this was very insightful. So I hope someone has questions in the comment box. And in case if there isn't any, we will start with the questions that came into our email. So I will start with the questions that came to our email. Okay, so the first question that we have is from a potential client, Mr. Rakibul Hassan. So his query is, I applied for an EB3 visa and received PARM approval. Now I have submitted by I-140 with premium processing. I currently hold a B1, B2 visa. My plan is to file the I-1485 adjustment of status while in the USA. Since I have already applied for the I-140, Will I face any issues at USA immigration when entering the country?
Most likely no, because I-140 by itself does not carry any intent. So, but yes, keep the receipt notes with you all the time. And if they ask you question, please tell the truth. Please tell that yes, I have a pending EB3 application. My perm is approved. I submitted my I-140. Now there's a long waiting period. It depends on the country where you're from. Depends on many factors. There's a long waiting period. So since you are here with a B1, B2 visa, most likely you have to go back to your home country or somewhere. You have to do something. So when you try to re-enter, they may ask you question, tell the truth, but there's no problem. You can definitely go out of the country and you can come back here. There's no problem with that.
Okay, that's great. I hope Mr. Mahajan has very immaculately answered Mr. Rakibul Hassan's question. So the next question that we have is from another potential client named Zanmul Huda. So the question is as follows. If my father is a green card holder in the USA and I am 27 years old now and married, can he apply for me under a family petition? How long might it take for me to get a visa through the US consulate office in Dhaka?
Yes, he can definitely apply for you. If he's a U.S. Citizen or green card holder, he can apply for you as a children. Of course, you're 27-year-old, you're married, so your category would be different. But yes, and how long it will take, it depends. It depends on many factors. Please follow Visa Bulletin. I have a video about how to read the Visa Bulletin. If you watch that video, you can learn about it. So you have to first ask your father to apply for you, I-130. And then you'll get a receipt notice with the priority date, and then you wait for the priority date to be present in the visa bulletin. Only then you can go for the second part. But short answer to your question, yes, he can do it.
Okay. So that is also another wonderful answer to the question. Okay, so the third question is from Mr. Bijoy Kumar Dash. The question is, I want to apply for an EB5 visa from Bangladesh and I don't have a B1 B2 visa. If I want to invest my money in a US company for around $1 million, and if I can transfer the money to the company's bank account, then do I need to prove the source of the fund, or can the US company prove the source of the funds?
Yeah, so since you are the applicant, it is your burden to prove the source of the fund. So please remember that there's two very important factors in either EB5 or E2 application. The legal source of the money. That's number one requirement. The source of the money must be legal. There must be a authentic source. Number two is legal channel of entry, meaning the money must come to America with a legal channel. So you said you're in Bangladesh, you do not have a visit visa. So it would be really, really difficult for you to bring $1 million to America from Bangladesh, unless you can bring the money from other third country, let's say from Dubai or Turkey or Singapore, Malaysia. That's a different story. But most likely, it would be almost impossible for you to bring that money to America in a legal channel. So I strongly advise you to talk to either immigration attorney who is capable of doing EB5 or a CPA or someone, tax attorney, to talk about this. But the fact you provided me, I am very convinced that you will not be able to bring that money legally to America.
Okay, I hope that answers your question, Mr. Bijoy. So now moving on to the fourth question. This is from Mr. Sadiqul Islam. So his question is, my uncle filed a family petition for me in 2009. Can I apply for a student visa? Will the family petition impact the F1 visa decision?
Of course, you can apply for the student visa. There's no problem at all. It will have no negative impact. It will have no positive impact either. There's no impact, no positive or no negative impact. However, in your student visa application, in your DS-160 form, please mention about that application. A lot of people, what they do not mention about any presence of the family-based application, family-based petition, but USCIS officers, embassy officers, they have full access to all the files. So as soon as they detect it, they already have a negative impression about you. So please mention the presence of that petition, mention about your uncle who applied for you. And of course, you can apply for a student visa. There's no problem. Now, the question is, are you going to get student visa or not? There is no guarantee that you will get the student visa. However, there is no guarantee either that just because there's a family-based application pending, your student visa application will be rejected. So there is no guarantee for either side. So I advise you to, yes, please apply for a student visa, but please mention about that petition and about your uncle in your DS-160 form.
Thank you so much, Mr. Mahajan. So we have one more question remaining from the email section. And this question is from Mr. Ashraful Haq. So the question is, I was banned from Canada for 5 years in 2022 due to suspicion of fraud related to my financial sponsorship under a student visa. Now, I want to apply for a US visa under the EB1 category. Will my Canadian visa rejection impact my chances of obtaining a US visa?
Most likely no. Even though the US, Canada, and many European countries, they share criminal records, but usually they share like a bigger criminal records, not like in a small petty crime or minor fraud related charges. Most likely it will have no negative impact, but it's very difficult to say because the law enforcement level communication is very common communication because US and Canada are bordering countries. They share a lot of information with each other. However, most likely they will not share this kind of information, and this may not have a big negative impact on your application.
Thank you so much, Mr. Mahajan. So with that, our question answer session ends. Thank you, Mr. Mahajan, for answering all the questions so beautifully. Thank you everyone for participating. Thank you, Mr. Mahajan, once again for your valuable time because we do not get these opportunities often from expert lawyers such as you. Okay, so concluding that.
Thank you very much, David, for inviting me. Yeah, please go ahead.
Okay. Dear audience, thank you so much for attending. Next week, we have another live session scheduled during the same time, which is 11 a.m. Eastern Standard Time. And for Bangladeshi viewers, we have the same time slot, which is 10 p.m. on Bangladesh time. So thank you, everyone. Thank you so much. Have a great weekend and enjoy your day. Thank you. Take care.
Asylum status is a form of humanitarian protection offered by the United States. Eligibility of asylum application. Every year, thousands of people come to the United States from different regions of the world seeking protection from persecution. According to the US law, one can apply for asylum if they have suffered persecution or fear that they will suffer persecution due to race, religion, nationality, membership in a particular social group, political opinion. Procedure of asylum application. You can file an asylum application if you are physically present in the United States and you are not a US citizen. There are two types of asylum application, affirmative and defensive. A non-citizen who is not currently in removal proceedings may apply for affirmative asylum through the USCIS. On the other hand, a person who is in removal proceedings may apply for asylum defensively by filing the application with an immigration court. From November 2022, affirmative applicants can file their asylum applications online. Asylum applicants can legally work in the U.S. while their application for asylum is still pending. Asylum applicants now can apply for employment authorization document online. Wherever the asylum seeker stays in the USA, Rajulo provides fast and accurate services with proper care. Rajulo, one of the top immigration law firms in the USA, is your trustful address for any assistance and advice regarding immigration to America. To know more, dial the number shown on your screen.